Hello everyone and welcome to the BRR Legal Brief, bringing you the latest legal issues affecting corporate Australia. I'm Kate Ritchie and today we're talking LAFHA, or Living Away from Home Allowance, which undergoes radical changes from 1 October and effectively cuts the number of people who will be eligible to receive the allowance. Joining me to discuss the changes are two partners from Middletons. In the studio we've got Philip Diviny, who's a partner in the taxation group. Philip, thanks for joining us.
Hello, Kate.
And also online we have Kathy Dalton, who's a partner in the employment practice. Kathy, thank you for dialing in.
Thanks, Kate.
Well, Philip, huge changes coming in next week. What's prompted the government to make these changes?
I suppose over time, Kate, the number of people who've been claiming the LAFHA has expanded pretty dramatically, and also the types of arrangements that have been subject to LAFHA has also expanded. So as you will have seen with the increase in foreign workers coming across, that's expanded the number of people on LAFHA, and the government has seen the need to chop it back to something more realistic. I mean, previously you've had people who've effectively been relocating their residents who've been offered a LAFHA as part of the package, and it's been essentially time unlimited. These changes will rule out those sort of people and obviously give you a 12-month time limit for the LAFHA concession.
Well, Philip, you've mentioned the 12-month time limit, but there's other changes being introduced. Could you run us through some of them?
Well, the main thing is the 12 months, I guess, Kate, so you'll no longer have an unlimited time to be claiming the LAFHA. And the second big thing is that you'll need to be maintaining a home in Australia that you're living away from home.
Yeah.
And so that is going to exclude a lot of people who are essentially relocating, or people who are moving within Australia and, say, keeping their current residence and renting it out.
Well, certainly one big group you mentioned were foreign workers who used to benefit. Have they effectively been cut from the new scheme?
Well, I think the long and short of it is that they have, Kate, because this requirement to maintain a home in Australia is a pretty rigorous requirement. It's going to make it uncommercial for a foreign worker to come and have a situation where they qualify for the LAFHA. I mean, I suppose they could come to Melbourne and rent a home there, which they then leave vacant while they go and work on a mine site somewhere and say they're living away from their Melbourne home. But the long and short of it is that, yes, those people on 457 visas will be out of the system.
Yeah. And Kathy, sorry to leave you hanging on the line. What about for employers? Are the changes going to impact them?
Oh, definitely, Kate. I think the key impact for employers, and most immediate impact, is that many of the existing arrangements, as Phil's mentioned, obviously are going forward not going to be FBT exempt, and for many employers that's going to be a really significant and potentially unsustainable cost for their business. So the immediate question, I think, for businesses is how do they deal with that cost? Can they change their arrangements so they no longer offer these benefits to existing employees, or can they require employees to absorb that cost? And that's not a simple one-size-fits-all exercise, unfortunately. It will turn on each occasion on what the terms and conditions are that govern the existing employment arrangement, or how the basis on which that benefit has been offered.
Well, it seems that the considerations are never that simple. If we look at transitional provisions, are there any included, or do people need to be ready for next week?
There are some transitional provisions. I guess to take a step back, these changes were announced in the budget back on the 8th of May. And so the transitional provisions say that if you had an existing employment arrangement and it has not been varied between the 8th of May and now, then you'll get transitional relief, whereby your 12-month period for the LAFHA won't start until 1 July 2014, okay? So that does give you some transitional relief. But for the people who are on the 457 visas, you need to have a home in Australia that you're living away from. So for those sort of people, they don't get the benefit of the transitional relief.
And Kathy, if I just come back to you, you mentioned some of the impacts on employers. How should they be going about managing some of these changes?
Well, the critical thing I think to do at the moment is for employers who are affected by this to be undertaking an audit or stock take of what their current arrangements are, and that's on a arrangement by arrangement basis, and that should be done as soon as possible to ascertain what terms the LAFHA entitlement is provided to the employees. Because for employers to act without having done this could very easily lead to breach of award and enterprise agreement claims if they stop making the payments going forward, make a decision to deal with it that way. There's a risk that they actually aren't able to do that if the entitlement has been provided under an award or enterprise agreement, which they can't contract out of. Similarly, some common law contracts of employment could make it clear that the entitlement is ongoing on a contractual basis. That needs to be assessed. The other important thing I think for employers to be doing at the moment, obviously in managing the change, is to be communicating with employees. We're certainly getting the sense there's a good deal of uncertainty, and this will impact on remuneration for some people quite significantly, potentially. And so communication early with employees in terms of how an employer is wanting to deal with this issue is very important.
And Philip, I don't know if you have any points to add there?
I think the issue there is to do with whether you continue to pay a LAFHA that's ineligible or whether you choose to top the employee up in terms of salary. Because if you pay a LAFHA, then it's going to be subject to fringe benefits tax, and the way that FBT works is it sort of assumes that everyone is on the top marginal rate of tax. So if an employer's of a mindset that they want to top their workers up for this, they're possibly better off doing it as a salary where it'll be taxed at the person's marginal rate than doing it as a fringe benefit, which is subject to effective tax at 46.5%.
Awesome, good advice there. Kathy, thanks for joining us over the phone, and Philip, thanks for coming into the studio.
Pleasure, Kate.
Thanks, Kate.
And listeners and viewers, we hope that you can watch us next week for our legal brief.